Good evening. Welcome to Reasonable Doubt. Just hold on. You might think, whoa, 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 what's going on? Is this a rerun? No, it's not a rerun. Tonight, I'm hosting for our good colleague, Julio Vela. He wasn't able to make it this evening. So tonight, I'll be your host with my co-host, Mr. Justin Harris. Good evening.
Hey, Todd. Thank you so much for filling in. And I forgot to mention beforehand that JB did want us to let people know that he is out sick. He is tested positive for the coronavirus, and he and his wife are hunkered down trying to weather through all this storm. So it's gotten real and touched our show as many people as it's touched around this world. So JB, Kim, we hope the best for y'all and that you get well soon.
Well, I didn't intend to bring that up, but if he gave you...
Sorry, Todd. I forgot. I talked to him earlier, and he said to go ahead and mention that so people knew what's going on, because he does want to address it with the viewers when he's able to. But right now, he can't get more than a few words out without having a coughing storm.
Well, and in that regard, of course, Reasonable Doubt is a program sponsored by the Harris County Criminal Lawyers Association, and we deal with matters in the criminal justice community here in Harris County. Tonight, we are honored to have Judge Elsa Alcala, who's had a fantastic career. I'm introducing her now, but I do want to understand that there's a lot of things to talk about. So we're going to just jump right in. Judge, thank you for coming on.
Well, thank you for having me. I appreciate it.
You were HCCLA's Torch of Liberty this year, and I think HCCLA intended to have you on earlier, but scheduling didn't work out for that. So tonight, it's all you. So let's begin. Who is Judge Elsa Alcala? Where are you from? What's your background, if you would?
Sure. So I was born in South Texas in Kingsville in 1964, which sounds a million years ago. And that's where I grew up. I became an orphan by the time I was 13. I think that's probably the most notable thing about my background. And graduated from high school. Then I stayed home at Texas A&I University, mostly because I didn't have any other options. That was the option that was there for me. So that's where I went to college. Then I was very fortunate. I went to UT Law School, and that opened up
in Austin.
I'm sorry?
UT in Austin, though, I understand.
Yes, UT Law School. And after that, I got hired by the Harris County DA's office under Johnny Holmes. And I worked for him from 1989 until 1998. Tried 3 death penalty cases, worked Special Crimes Division, the larger dope cases. And after 9 years, I decided to apply to be appointed to be a judge. And I applied under George W. Bush's administration. And he appointed me to the 338th to replace Mary Bacon.
Mary Bacon, I didn't know that. I do want to pause a moment to discuss your time with Mr. Holmes. Of course, he's legendary in terms of Harris County District Attorney's Office. Your thoughts about your time there under him?
Well, Todd, when were you there? I'm trying to remember that right now.
I've been a lawyer 20 years now. So I do believe that when I was ultimately licensed, I think it was Chuck Rosenthal there.
Yeah. Well, that's too bad for lots of reasons. Johnny Holmes was really conservative. I mean, I don't think anybody's going to tell you otherwise. He sought a lot of death penalties. He thought if it met the statutory criteria, for the most part, you then gave it to the jury and the jury decided. So Harris County was really a powerful voice in terms of the death penalty and seeking it and getting prison time. He, even probation and deferred was somewhat rare. Yeah, even like an aggravated robbery, we giving deferred on an aggravated robbery was just a shock, is my memory of it. It just didn't happen. So it was a pretty tough place to work in terms of punishment being prison time or your life. And so the office was interesting for that reason, I think.
Are you saying, from the standpoint of the citizen accused, in terms of punishment back then?
Yeah, for the citizen accused, I think he was really tough on punishment. And of course, I've changed my thinking on that, in the last 20 something years. But back then, that's how I was raised, so to speak. And when you look at, for example, Kim Ogg and her current administration, she was there a few years before I was. So that's the culture that she was raised in, so to speak, as well. And we can talk more about her later on if y'all want, but that was the culture of the office. That being said, I have a lot of fondness for Johnny Holmes. He, in my mind, had a lot of integrity to him. He said, even if you make an offer on a case and it turns out to be the wrong offer, if that's the word, that's your word. If that's the offer you made, then you live by your word, even if you end up regretting it. So
Sure.
he really preached a lot about morals and ethics and your word meaning everything. And so I have really only good things to say about him, even though at the end of the day, I end up really disagreeing with the punishment philosophy. After 20 something years, I've gone in another direction. But I think he was an honorable man, a decent man, and I think most people who talk about him really have a great respect for him.
And I've known many people that work for him as well, and I'm pretty sure they have the same opinion.
Yeah.
Who was his predecessor? I'm just drawing
Carol Vance.
Carol Vance.
Yeah.
And of course, I mean, I think Mr. Holmes carried through with some of the philosophies of Carol Vance. But we're talking old school Harris County.
Yeah. But
Okay.
actually, if you know about the old school, it kind of helps you to understand what's going on now. It helps you understand a little bit where Kim is trying to say that she's a progressive prosecutor. Well, she is, as compared to 25 years ago, but she's not as compared to what's going on in the rest of the country in some true progressive jurisdictions like, Philadelphia and New York and some other places that are really moving the ball forward. So that's my quarrel about that term with her, is that you shouldn't be comparing her to 25 years ago when we just didn't know better, in my view.
The comparison doesn't work.
Right.
Can I ask a question real quick?
Please.
Judge, you a couple times you referred to like that you've had some evolutionary changes in your feelings. You're the recipient, as Todd mentioned, of the Torch of Liberty Award from Harris County Criminal Lawyers Association. Congratulations on that.
Thank you.
We do have the awards on the way, and you'll get that as soon as we get it. But I just want our viewers to kind of understand. I know some of the things that were considered in awarding you that recognition, but I think your evolution and some of your changes has something to do with that. Can you kind of talk about that a little bit?
Yeah. So I was a trial judge for 3.5 years, and I would self-describe myself as, and this sounds negative, but it's not intended to be negative, as somewhat unremarkable, meaning that I was one of the 22. I wasn't out there, getting any headlines or doing anything outside of the norm, is how I view myself as a trial judge. Then I went to the Court of Appeals. It was the first Court of Appeals, and I became a appellate justice there. And the thing about an intermediate appellate court is that you are bound by the precedent of a higher court. So even though you might look at a set of facts and think, gosh, that doesn't sound right, you are bound by higher precedent. So you really, if you go outside of higher precedent, you're just going to get reversed and make a fool out of yourself for the most part. So at the intermediate appellate court level, I tended to apply established law, and I can't say I reached out beyond that very much. It really wasn't until I got to the Court of Criminal Appeals that I started seeing a lot of precedent that I thought, this can't be right. This is wrong. This can't be right. And
Right.
at first I thought, well, I need to just follow it. It's precedent. And at some point after maybe the first year, maybe the first few months, I told myself, you're on the high court. You don't
Yeah.
have to follow this ridiculous precedent just because it's precedent. You can make a case for why precedent should change and why this is the wrong result. And so I think if I have a change, well, I do have a change. It happened when I got to the Court of Criminal Appeals, because that was the first time I felt like I was in a position to actually apply the law evenly as compared to applying the precedent that had already been set forth.
It appears that Governor Perry appointed you, is that right?
Yes.
Of course, we know he was probably still is super R.
Super what?
Super Republican, I mean.
Yes, but remember, he was also accused at some point here. He had a
Right.
criminal accusation against him. Now, I don't know the timing of that with respect to my appointment. It might have been pending. I can't remember. I think it was pending when I was appointed. So he knows what it feels like to have an accusation. He ultimately prevailed, but it was after, I think, more than a year of litigation, pretty hard prosecutor that came after him. And so I've always thought that I think Perry would be happy with everything I did. I wasn't one to just blindly apply precedent, but I was one to actually question how and why. And ultimately, he ended up winning against a prosecutor.
Admittedly, I'm not an appellate lawyer, so I don't roll around in the ins and outs of all the CCA opinions. But I'm reading perhaps from you that perhaps harmless error might have been a concern for you. Like, what were some of the big issues at CCA that you thought, maybe I should change some of this? I don't know. I don't know the answer to that.
Well, okay, so I'll tell you, I think this was literally one of the first cases that I came across, one of the absolute first. And it was out of Harris County, and it was a death penalty case. For the defendant's name is not coming to me right now, but it may as I'm talking, and it doesn't matter. But he'd gotten the death penalty, but it was a case where the defense lawyer put on a defense at guilt. The defense lawyer felt like the state could not prove that the victim was a peace officer because he was in plain clothes or something like that. The defendant was found guilty. By the time they get to punishment, the lawyer confesses error and says, I didn't present a case at all, a defense case in punishment. I didn't investigate punishment. I didn't put on a case. And he might have called like one witness to say something very minuscule, or called nobody, I don't remember, and then rested right after the stay. So this is a death penalty case with no punishment defense at all. And defense counsel is confessing that he was ineffective in the punishment phase of trial.
But,
So
but
I look at that.
He was saying in appeal, or he said in the record at trial?
On a writ. It was on a writ, on a death penalty writ.
Okay.
I'm sorry, I'm not sure what I said, but it was a death penalty writ.
He admitted IAC on himself.
Yeah, exactly. I looked at that and I thought, 5-minute easy opinion, reverse on punishment, new punishment trial. I mean, I literally thought it was that easy. I get the paperwork, the internal paperwork, and this ultimately got issued, so I'm not really speaking out of turn, but Judge Keller wrote the majority opinion, and she upheld the death sentence. And I think it went down 8-1. I think I was the sole dissent. Maybe there was another one there. I don't remember. I ended up writing a dissenting opinion, and the majority view was that, it didn't matter that the defense lawyer had admitted that he was ineffective. It didn't matter that no defense case had been presented at punishment because, like you said, it's all harmless. The jury would have given death anyway. And of course, I said, well, how do you know that these 12 jurors would have given death anyway if they had heard his defense case that they had presented in the writ? They'd done some investigation and found some defense evidence. And Keller and the rest of the judges just said, well, we know basically because we know, we are all knowing and all seeing, and we know because we know. And I just saw a text message here from Inger that the name of the defendant was Arthur Williams. And just to fast forward here, there is a happy ending to that story. His writ lawyer was Randy Schaefer, who, as y'all know, is a dog with a bone. He doesn't give up. If you fast forward to 7.5 years that I was on the court, I think it was December of my last year on the court that Arthur Williams got relief by a federal district court judge, and then his sentence got ultimately commuted to life, and he ended up not getting the death penalty. But that case lived through my 7.5 years. It was literally there for me when I walked in the door, and as I walked out the door, he had gotten a life sentence. But that is a classic example of Court of Criminal Appeals. If you want Court of Criminal Appeals 101, that is it.
What about the 5 minutes late brief that was filed? That's not the same case, is it? Or
say that again?
The brief where the briefing was filed 5 minutes late?
No, that's another one. That's before I got there. That was
Okay.
Richard was that case.
I mean, there's just some really hinky things sometimes that happen.
Oh, in that court, there's more stories than you have time for. There's a lot of problems with that court, and I won't spend the whole time talking about them, but the court has significant problems.
And this might be a good segue. At some point, I mean, your career up to that point has been as a Republican, respectfully, but you decided to change parties. And I think it's around 2019, if that's accurate. Tell us what happened.
When Donald Trump ran, well, let me start backwards a little bit. So Perry appointed me in 2011. And then I had to run again. I had to immediately run in 2012. And that's a long story about my running, but it had issues where I had a Republican opponent for a little while who I think was running against me just out of prejudice. I mean, he had an Anglo last name and I had a Hispanic name, and even the New York Times wrote an article about my race saying that there was no way that I was going to win in the state of Texas because I have a Hispanic last name. That was in 2012. I ended up challenging his ballot, his application to be on the ballot, and ultimately he was knocked off the ballot, and ultimately I was unopposed. But that was about 6 to 9 months of me being opposed, and I felt being opposed simply because of my ethnicity. And there was no other reason. He had a very Anglo-sounding, easy name, and he figured I was, an easy one to pick off. And I think he was right. Had I not challenged his ballot petition, I believe to this day I probably would not have gotten the Republican primary vote. And to give you a quick example, at one point there was a straw poll in Fort Worth, and I went to the straw poll with my then husband and my kids, and we were there like 8 hours handing out push cards and campaigning and introducing ourselves and working the straw poll. At the end of and my opponent didn't show up at all. He was just a no-show. At the end of the day, there was a straw poll vote, and my opponent won the straw poll.
Okay.
And I thought, I am losing this race. There is nothing I can do if I'm going to lose. I'm going to work and campaign and do everything, and yet I'm still going to lose because I have a Hispanic sounding name.
That's
So that
absurd.
kind of, yeah, it was ridiculous. So that kind of had, an impact on me to some extent. But in my view, the Republican Party is kind of split, at least back then, because while you had that group that obviously preferred an Anglo-sounding name, you also had a lot of the Republican Party who I felt were welcoming minorities and Blacks and people of color into the party, because they were they know that you have to be more expansive, that you're never going to have a long-term party if it's just going to be Anglo people. So in my view, the Republican Party's been a split. And I was okay with that for a long time. It really wasn't until Donald Trump got the nomination that I thought, I can't be part of this party. I can't have an R next to my name and having them wave me around like a prize. Oh, we have people of color in the Republican Party. Look at her. And I'm thinking, no, don't look at me, because I'm not going to be your puppet that you're going to wave around to show that you're open to all people. So it was really when Trump got the nomination that I had a real problem.
I want to pause right there real quick.
Okay.
But historically, there have been humans that were Dems that ran as Rs in Harris County, particularly in the late 80s, early 90s, to get elected to do well the best they could on the bench. I mean, that phenomenon exists. I mean, we'd be silly not to remember that. But nevertheless, it was under the umbrella of an R. I mean, of course, you remember that.
Yeah, but I can't say that was me. I am a fiscally conservative person. Even just by nature, I'm a fiscally conservative person.
I didn't imply that on you. I'm saying that some folks, not you, but some folks ran to get on the bench to do the best they could for society. And Judge Whitman, he's in heaven now. He was one of the youngest elected judges in the history of Texas. But if you asked him before he deceased, he'd say it was a Dem. But the only way to get on the bench was to be an R. I mean,
that's
about Bruce Whitman, not Greg Whitman.
Well, the only other thing I'll add to that is that judges are prohibited from really talking about political issues. You're really not supposed to be saying, oh, I favor this and I don't favor this, or I'm against this. You're supposed to be silent on that, so that if a case involving whatever the issue is comes in front of you, you're not perceived as being prejudiced on the issue. So I probably have always been in the middle. I was either going to be a liberal Republican or a conservative Democrat. And I probably am still in that middle zone. I'm pretty really liberal when it comes to anything progressive on criminal justice, on um, gay rights, gay marriage. I've gotten probably most liberal of liberals on those issues. When you get to fiscal issues, I think I still am more on the more conservative side, and I have to fight that in me sometimes, where somebody mentions something about money and my first reaction is, no, you can't afford that or whatever, and I usually have to be talked into another direction. Somebody will have to say something like, well, we're spending X amount on the military or something like that. Why can't we redivert the funds? And then I think, oh, yeah, you're right. Of course we can. But my initial reaction is always, we can't spend that kind of money. We don't have that kind of money. And just to give you an example, my kids laugh at me. I've spent probably 2 weeks painting my house myself. And my kids keep saying, why don't you just hire someone? And I keep saying, I'm not going to pay somebody to come and paint this house. So consequently, if you look at my hands, I'm covered in paint because I won't pay somebody to come paint the damn house, but
Fair enough.
but that's just still part of it. Is I see that in myself and I have to fight it. And I think, I grew up poor. So when you grow up poor, you really value that dime and you really don't want to spend it.
Well, at some
I wanna-
point,
If I,
sorry, Justin. Please.
I'm sorry, Todd, I didn't mean to interrupt you.
Well, no,
I-
at some-
To hit on something you said just a moment ago, Judge, about judges in Texas are supposed to, they have to affiliate with a party. I guess maybe they don't have to, but to get on the ballot, you got to have enough votes on your petition, and they have to campaign against whoever's campaigning for the same bench they are, but they can't talk about any issue. So it's kind of an interesting oxymoronic experiment in democracy, electing judges, because the voters are left with, I guess maybe two choices. They have to decide who's going to be the best jurist to select of these two, but we can't know anything about what they're going to decide or how they're going to decide issues. I'm not saying we should. I just think that's an interesting thing. I don't know, as someone who has run for office and also been appointed, run for the bench and also been appointed to the bench, do you have any thoughts on that whole process or system?
Yeah, I spoke on a podcast recently, and that was the subject about judicial selection. The bottom line for me on it is that when you're talking about jury selection, you're looking for the best of all the bad ways. In other words, every single way of selecting judges is problematic. So
Right.
You're looking for the best of the worst. And to me, they're all bad. So I would just leave it alone because electing judges is a terrible way to select judges. But judicial appointment based on, look at who Trump has appointed.
Right.
I don't have any
Barely call those
confidence.
people lawyers.
Yeah, so I don't have any confidence that those people are any more qualified than those random people we're getting by voting. So to me, they're all bad, and I would just soon leave the election process in place, even though we know it has resulted in some terrible judges being elected.
a hardcore right person would just scoff at you and how dare you leave a party that you've been involved in for so many years. I'm sure you probably get that too. I'm not here to encourage that or embellish that. The point is, you yourself decided that in last year enough was enough and you switched parties. Is that right?
Well, you're right. And the truth is, I didn't like Trump when he was first elected. I can't remember I guess we're now in 2020, so that was 2016, I guess. I'm not sure. Or 2017, anyway. But I was on the court as a Republican when that happened. And I told myself, should I switch parties while I'm on the court when I was appointed by Perry and I have been elected by the Republicans, or should I just shut up finish my term.
That would have been scandalous.
Yeah, it would have been. And Larry Myers did that. And I just thought, what, other than a scandal, what is gained by me doing that while I'm on the court? So I just told myself, finish the term. Then I have finished my obligation to Perry and the party and everybody else. Then I'm on my own. So that was end of 2018 when I left the court. In 2019, I went to become a lobbyist for the Texas Defender Service for 6 months during the session. And again, I thought, I wanted to announce then, but I thought, I don't know how this affects my client who I was lobbying for me to switch parties in the middle of a legislative session. So I just told myself, just be quiet. And finally, when I stopped working as a lobbyist, I felt like I had the freedom to at least come out of the closet, or however you want to put it. And so that's why I did it in the summer, I think it was, of 2019. I didn't feel beholden to anybody. And really, honestly, I thought people were going to kind of give it a big yawn, like, okay, whatever, this former judge is switching parties. Who the heck cares, is what I thought was going to be the response. Instead, it went into national news and everything else. I think, so many people dislike Trump that it was just one more thing to write about. And it was probably just a slow news cycle. I don't know. But a lot of people were interested in it.
Well, and since you've been very vocal, at least locally here,
Yeah.
I don't know what you do beyond Harris County, but certainly enough to get the attention of the Harris County Criminal Lawyers Association. That, as Justin mentioned earlier in the program, soon thereafter has given you an award for Torch of Liberty, which we don't hand those out. I've been involved in that organization probably 17 years. I know that there's a lot that goes into that, the nominations to begin with. And then, of course, the board takes their time and makes a choice. And respectfully, you were that one for last year. So
Thank you.
that's on you.
Well, thank you. I was surprised and really honored by it. I certainly didn't expect it, but I'm grateful for it and very appreciative.
Now, so we've done the background. I told you I thought it'd take 10 minutes. It took about a half hour. Now let's look forward. There's a lot going on right now and a lot to talk about. We're all vocal about this. And so I think at this point, we can all kind of free flow here, but it seems the logical place to start is COVID and jury trials. Thoughts?
I mentioned this, I think, to Neil at some point, and I said, I feel about myself that a lot of times I can come up with a good idea. Give me a problem and I can come up with some kind of good idea. When I think about the jury trial problem, I can't come up with any good ideas. I'm stumped. And I wish I had something really brilliant to say about how to solve the jury trial problem.
Well, Harris County authorities aren't waiting on us. They're moving forward, as we know. Mid-July, there's going to be a trial to resume. And they're going, these folks are, without inquiring into, at least my understanding, to the PD's office, the Harris County Public Defender's Office, or our organization about any input. I'm saying zero input for our input. They are moving forward with trials with jury selections at NRG starting soon, which is incredibly stupid. It's incredibly stupid. But this is what is happening. And, I don't want to bring up But we have people right now in very bad shape that got COVID a week ago. There's going to be people getting COVID tomorrow and 2 weeks from now. And we don't know how their bodies are going to react to this thing. Some take it mildly and are asymptomatic. Some get put down and some die. Yet, the powers that be in Harris County are pushing forward an agenda to get trials at NRG Stadium without conferencing defense. This is incredible. It's incredible. And I'm just using this as a platform tonight. There's others that have the same ideas that I do. Perhaps not so eloquent.
It's a problematic on every level across the board. Every time I talk to other attorneys or I read a report from another organization I'm involved with, there's another thing I hadn't thought of. Makes a huge problem with conducting a jury trial. And I'm like you, Judge, I don't have necessarily a solution, but I know what's not a good idea. It's exactly what Todd's talking about. I can tell you what's not a good idea. I may not be able to tell you what is a good idea, but I can smell a bad idea, and this one stinks.
Well, I mean, just be ready with that good objection is all I'm saying is you're going to probably have a good, 10 grounds for objecting, beginning with the composition of the jury itself, right? The prospective jurors are all already going to be whittled down to people of a particular mindset because the other ones are not going to show up.
Exactly.
Then you've got a problem with just the communication and being able to see the faces and the facial expressions and the tone and all of that is going to be difficult. But you present a good question between the continuation of a jury trial where you've already done jury selection as compared to the problems with jury selection, because those to me are different issues. And the ones that's continuing, the trial that's continuing, those are some exceptional lawyers. I'm sure they're going to have a litany of reasons why however they're going to do it is not going to be helpful.
I can understand the need and desire to push forward with a trial that's already begun. You've got all kinds of problems. The longer a jury that's already sworn in sits, the more chances there are that something happens to them that may have disqualified them as a juror in the first place. Or, they get sick and possibly pass away. And then what do you do with an incomplete jury panel or jury? So I can understand that trial. It's a big trial. It's been geared up for a couple of years. That one picking back up as soon as possible. Get it out of the way, but don't start with more of these. And there's just, sure, we do jury selection at NRG Stadium. Where is the jury going to deliberate? Where are they going to go for bathroom breaks?
Well, no, they only pick the jury at NRG. You go back to CJC, and that's cesspool of germs, and then they allegedly are going to sit in the in the audience, social distancing.
Well, how do they deliberate is what you
Right.
just said.
How do they deliberate?
6 feet apart, deliberate.
How do we have an open courtroom?
Listen, let's be honest about it. But the intellectual issues, there are humans that need trials.
Right.
There are humans that have been waiting years, and I have some clients that have been waiting years for jury trials. I do. Some of us do.
I do, yeah.
Counter that or balance that with humans' individual safety.
Right.
I mean, this is something. I mean, if you go up 30,000 feet here, these are issues that none of us have thought about in our lifetime, and we're trying to attempt to reconcile them with the notion to give the citizen accused their day in court. And of course, this is what the reason HCCLA was invented. This is the reason TCDLA was invented, or NACDL was invented. We champion for the rights of the accused. But at some point, you have to balance individual safety, because this virus, short of my friend getting jacked up with his thing, I've just been kind of living in my own world here. But this thing has the ability to kill you. Kill you. And I don't know about you, but I'm not ready to die yet. And I'm certainly not ready to get sick so bad that it feels like death, while some may be asymptomatic. You know, this
Not a
virus
risk. Not a risk. We take.
discriminate.
There's no way to know who's going to be asymptomatic, who's going to have a mild case, who's going to have a severe case. And sure, death and serious illness are affected. But I was just thinking earlier, what would happen if I'm laid up for 2 weeks? I don't know. I'm not going to be able to make any money. We're going to drain our savings account that we've spent 2-3 years building up since Harvey devastated everything. And you know, you're right. But the purpose of government is to ensure life, liberty, and the pursuit of happiness. The underlying thing below that is everyone's health and safety. So this system just doesn't really work. The criminal justice system, at least, maybe a broader political system, just doesn't work amidst a pandemic that requires everything to kind of come to a halt, just so that we can ensure that underlying thing, to be able to be living or have happiness or liberty, we've got to first be alive. And I don't know how these things are going to work together, because you're right. There are people who've been waiting a very long time for their day in court, and they deserve that, and they need that. But how do we do that and ensure people's safety?
Well, my opinion. Please,
no, go ahead. No, I was just going to say, every lawyer needs to have the words confrontation clause in their, whatever comes out of their mouth needs to include confrontation clause, because that's the problem at the end of the day, is that because of the distance between the jurors and the witness, they're not going to be truly confronted. It's all that old case law from back when I was a lawyer, you know, the confrontation clause involving the video camera use with the sexual assault victims, and then the confrontation clause in other contexts where there's a barrier or something that's interfering with the lawyer's ability to confront the veracity of the witness. So that's what I would tell people. You know, you may have other statutory grounds, but when it comes to the U.S. Supreme Court and federal courts, they're looking for that federal constitutional argument. And to me, that's the argument that's probably going to get their attention more than anything else. But I would preserve the hell out of these complaints.
I was on a multi-defendant conference call. No, the federal courts didn't require us to come in. We had a conference call, probably 13 or 14 lawyers called in, defendant's appearance waived. And the court recognized reasonably that the ball is going to be pushed back from August.
Right.
And it's probably going to be pushed back further. And it might likely be that we don't have jury trials this year,
Right.
which is disheartening in the sense that there are humans that are incarcerated that have to wait for their trial because of a worldwide and certainly, you know, a United States pandemic. It's not none of us' fault here, but that's how it is.
Well, I mean, it is somebody's fault in my mind. You know, you have a DA who has the power of the pen, right?
Right.
The power to dismiss a case and refile it, the power to negotiate. You know, you're charged with this, you've been in custody this long, let's work this thing out. And in my mind, we don't have a DA who's enough of a leader to take control of the situation. So all you have is a jail population that's going higher and higher and higher because you don't have a DA and assistants who are taking control and trying to work things out and get with the mindset of getting people out of jail. You got to get people out. It's got to be a fire sale every day. You've got to be offering lower than your wildest dreams to get these people out of jail, in my mind. They should not be in jail. And I also blame Governor Abbott because of his ridiculous executive order that tied the hands of judges from releasing people on pretrial bond. You know, he said if you have had some kind of crime of violence, even like 30 years ago, that the judges couldn't give a pretrial bond. And that's
GA
just
13
ridiculous.
GA 13 is still in effect as we speak.
Well, it's
What
ridiculous.
what would you say if that came up to you? Can you say if you were still in the Court of Criminal Appeals and that came up to you, is that a constitutional order from the executive branch?
As a trial judge, I would declare it unconstitutional and I would grant bail. Now, then what would happen is they would appeal that, I think, to the Court of Appeals first. It's not a direct appeal to the Court of Criminal Appeals, I don't think. It would go to the intermediate court. You have pretty defense-friendly intermediate courts in the Harris County area, I think. So
Well, I
they
don't know.
might,
That seems like a clear constitutional issue, defense friendly
it
or
is.
state friendly. And I don't know how that necessarily helps the prosecutors either when they're out there making deals thinking that they're going to get, the defendant's going to get 3 for 1. And then they find out, oh no, thanks to the General Order 13, can't do that.
Well, if I were Tim, I would be adjoining the defense in the sense of the governor has no, it's a separation of powers problem, that the governor has no right to be interfering with the judicial function. So
Right.
all should be joining with the defense bar to declare that executive order unconstitutional. And then that needs to work its way through the appellate system. But you need a trial judge. I don't know if a trial judge in Harris County has declared it unconstitutional yet. If they haven't, I don't know why they haven't.
Judge Morton in the 230th declared it unconstitutional.
He did. And
I
then
don't know where it is in the process.
Yeah, that's what I was about to say. Well, that's what needed to happen. But why haven't they all declared it unconstitutional? What are there, a bunch of sheep? It's like, come on now. It is an unconstitutional order. Declare it unconstitutional and then let it work its way through the system. Why is everybody a bunch of sheep and just following this thing that we all know is unconstitutional?
Well, we don't know if it was raised in other courts. I certainly don't. I do know it was raised in Morton's court. Look, you have the governor's 13, you have the general bond order in Harris County, you have the district attorney's office, who right now under Kim Hogg, I mean, we could have another hour with regards to Ms. Hogg and the apathy and the things going on in her office right now. You have the pushback with the sheriff's office. Of course, there's the lawsuit. And we've now recently seen Judge Silverman join as an intervener. I believe yesterday, intervening into the Bell lawsuit in federal court. This isn't a easy situation to grapple with regards to the legal issues. The legal issues are profound. But all players here need to be at the table, in my humble opinion. And there's people eating food at different tables and not inviting other people to talk and eat and drink at those tables. That's a problem. But I don't know how we fix it. We can't literally get up to hang out together and talk. In your lifetime, could you imagine that you would ever, first, report to court via Zoom, second, walk into a bank with a mask on? Could you imagine that in your lifetime? Because I can't.
No, I mean, I can't. We are in this other realm. But I guess to me, people should rise to the occasion. I feel like I see a bunch of people who just are sitting back and just going along with the flow, and let's not be creative and let's just do what we've always done. And then you do have some judges, like Judge Morton, who declared it unconstitutional, who are trying to, to move the ball and think outside the box a little bit. And I think that's what we need, are people who are willing to think outside the box and maybe be a little more creative than in the past.
I'll tell you, at least in my experience, almost every judge I practice in front of in Harris County, and that's a lot, have on their own reviewed all their bonds, have given a lot of PR bonds to people. Like, I think the judiciary is internally doing what they need to do. That doesn't change when we have trials. But I do believe the Democrats in our county are kicking ass. Mark, I don't know if I can say that, but they're internally trying to help. There are some people with the allegations of their crimes that have to stay in custody through this thing. And yes, they may catch COVID, which is incredible. And God bless and hope they survive it. But this is how it is. I mean, we all struggle with this daily. I work 7 days a week at this thing from this same desk. But there's no readily answer for us. We all have to pitch in here. We all have to push just a little. Just push. Everybody push.
I'm not sure I entirely agree with what you said about, all these judges are doing so great. I mean, I know of, and I don't want to reveal names or anything, but I know of a young man who I believe is innocent, who was arrested as a protester. He had to show up in court. He was arrested like on a Friday, and he had to show up in court on a Monday at 9. He got there, saw crowds along the way. He got to court and he shows up at 9, and then he says, the judge isn't going to be here until noon. So he sits there for 3 hours waiting on this judge. And then ultimately he asks for an appointed attorney. He doesn't get an appointed attorney, and then he ultimately has to go and hire an attorney. And so on the one hand, he was given a pretrial bond, and I think, well, good. That's good. That's good on the system. He got out of jail within about maybe 36 hours. I'm not sure. On the other hand, why was he told to show up in person? Why couldn't he reported by Zoom? He's a smart young man. He easily could have reported by Zoom. Why did they make him show up in person? And then when he showed up, why did they make him sit there for 3 hours for this judge to either show up or get around to it or whatever? And then why didn't they give him a free attorney or a public defender when he's a student and he doesn't have a job and he relies on his parent for all of his support? So
we've got about 2 minutes.
Okay. So anyway, I quarrel with this idea that the system is working so great. I don't think it's working so great. And this is all very recent. This was as of a couple of weeks ago. I think some judges are doing great. I think that particular judge is doing a pathetic job. And I heard that from lots of people along the way. I've kind of given up naming people because I'm not sure it's helpful. But the system's not. The system is imperfect in my mind, and we've got a lot to do to make it better in the next few months, or we're going to keep continuing to infect people at the jail and at the courthouse.
Justin, any final words?
Well, I think we still have maybe a minute more than Mark said. Mark, we still got a little bit more than 3 minutes now, or right at 3 minutes. Judge, I just have, I don't know if you can answer this in like maybe 30 seconds, but can you dish it all? When you're on the Court of Appeals or the Court of Criminal Appeals, you've read the attorney's briefs, or do all the judges and justices actually read the briefs before the oral arguments? Do oral arguments make any difference? Have they ever changed? You've heard something and changed your opinion on that? I'm just kind of curious about that.
I do think oral arguments can make a difference, even though most judges will tell you that they don't. But I think they have and they can. Usually when it's a situation where there's like a misunderstanding, like I remember one time I had read everything and I thought the facts were X. And then the lawyer got up there and spoke, and the lawyer presented the facts as Y. And I thought, oh my gosh, I just completely blew it. I just didn't get it at all. So I think sometimes when the lawyers stand up and they can make something really complicated simple, like if they'll say, this is really this messed up thing, but if you'll just focus on this one thing, you will see that you can easily rule my way. Something like that, I think, can be really powerful in oral argument. No, the judges don't read. A lot of the judges don't read all your briefs. It's the lawyers, the staff lawyers that are reading it. So it is important that it's a good job that you present, because the staff lawyer is the one that's reading it and maybe presenting a memo from it and giving the judge that point of view. It's not to say that it's not the judge's ultimate decision, but it is to say that a lot of times the bulk of the reading is by staff lawyers. And I was guilty of that too, although I did read what I viewed as the pertinent parts of either the brief or the record. I would do like that quick reading,
We got 30 seconds, Your Honor.
You read really fast.
It goes
Focus
quick.
on the meat.
Well, I'd love to have you back on and talk more about that kind of stuff. So thank you. That's all.
Oh, well, thank you for having me. I know I always think I have nothing to say, and then I can't shut up.
That's
All right. Well, Your Honor, it was my pleasure to visit with you. I'm sure Justin as well.
Yes.
Thank
So
you.
you and your family, please stay safe and take care of yourself, okay? Justin, Mark, you the same.
Thank you, Todd. You as well.
We're going to go ahead and wrap it up. God bless everybody.
You too.